In this video, I'll take you through the probate process with the most important steps, from finding the will after death, distributing assets to beneficiaries, and eventually closing out probate. Probate can be difficult due to the emotions of losing a loved one, so it's important to understand the basics of probate as early as you can in order to make a very difficult time less so. When someone passes away, the first step in the probate process is typically to establish if they left a will. Well, usually family members are often aware if a will exists. Otherwise, a search through the deceased's belongings, including their papers, a home safe, or a safety deposit box, may offer some clues. Additionally, if the deceased had a lawyer, it's worthwhile to inquire if that lawyer had any knowledge of a will. After the original will is located, it must be filed with the probate court in the state where the deceased person had their permanent residence at the time of their death. If the original will is lost or destroyed, a copy of the will can be submitted to the court, but the party submitting it must prove that there was no wrongdoing. However, simply submitting the will to the court does not initiate any legal action. The personal representative named in the will must petition the probate court to approve the will as the final testament of the deceased. After a petition for probate is filed in most states, the probate court typically requires that notice of the petition be given to the deceased's heirs and other interested parties. This notice may also be published in a local newspaper. If you have any objections, you or your attorney should file an appearance by a certain deadline indicated in the publication and notices. If there are no objections to the petition for probate, the personal representative named in the will or the administrator named in the petition is usually appointed by the court to administer the estate. Their responsibilities include locating all assets in the deceased's name, settling the estate, filing tax returns, and ultimately distributing property to beneficiaries. The personal representative must also prepare and file an estate inventory soon after their appointment. The personal representative must file a complete inventory of the estate's assets within 1 to 3 months of appointment, depending on the state. This inventory becomes a matter of public record and serves two purposes. First, to indicate the items of the probate property for which the personal representative will later provide an account. And second, to inform beneficiaries, creditors, and other interested parties about the contents of the estate. To ensure a timely settlement of the estate, states set time limits for making claims against the estate, which typically start from the date of death or when the personal representative is appointed. The period usually lasts from 6 to 12 months, and any claims made after that date may not be collectible, even if they are valid. The personal representative must make reasonable efforts to identify and notify all known creditors so that they can file a claim within a specific period. As the personal representative assesses the estate's liabilities, they must also determine outstanding debts, fees, and expenses that could impact the estate taxes owed. This includes medical bills, utilities, income taxes, and legal and accounting fees. It is the personal representative's responsibility to file the necessary tax returns and ensure timely payment of any taxes owed, typically due within 9 months of the deceased's passing. Claims and expenses without dispute are usually paid within this period. To settle the deceased estate, the personal representative must prepare estate tax returns that show all of the property included in the estate. The returns must be filed and the tax paid before the estate can be settled. If the returns are filed and not accepted, the government may ask for more information or even, God forbid, audit the estate. Until the returns are accepted and the final tax liability is agreed upon and paid, the personal representative should not distribute all of the assets. If there is not enough money left in the estate to pay the remaining tax due, the personal representative may be personally liable for the payment. However, if the estate is small enough, there may not be a need to file a federal estate tax return at all. Once the returns are filed and accepted, the government will give the personal representative a closing letter stating that no further taxes are due. This is usually followed by the distribution of assets to the beneficiaries and eventually the closing of the estate. Once all taxes and bills have been settled, the personal representative can distribute the remaining assets to the beneficiaries according to the deceased's will or state laws. But before making any payments or transferring property, the personal representative should prepare a release for each beneficiary to sign, accepting the proposed distribution and releasing the personal representative from further claims or personal liability. The beneficiaries may also receive a detailed financial report, the final account, if you will, outlining all estate transactions and proposed distribution. While beneficiaries are asked to review and approve distributions and accounting, objections can be raised to the personal representative or even to the probate court. It's essential for beneficiaries to carefully review the account before signing the release to avoid any future disputes regarding fees or expenses. Once all debts, fees, and taxes have been paid and the final account has been prepared, the personal representative must decide whether, at that time, to close the estate. They have three options: keeping the estate open indefinitely, closing it informally within a year, or closing it formally through probate court. If the personal representative chooses to formally close the estate, they will submit their final account to the beneficiaries as well as the court for approval. Once the account is approved, the estate can be closed, and the personal representative will be relieved of all duties and liabilities. And as a final reminder, here are the primary steps in the probate process. First, locate the original will. Second, file the will in probate court. Third, notify heirs and all interested parties. Fourth, appoint the personal representative. Fifth, file an inventory of the state's assets. Sixth, pay all claims, fees, debts, and taxes. 7. File the tax returns. 8. Distribute assets. And finally, number 9, close probate. Probate can be straightforward if you understand the process and if the estate is not overly complicated. But it's imperative to seek qualified counsel if necessary and work in a detailed and organized manner. Unfortunately, however, the probate process and distribution of assets can be emotional for many, and dealing with unruly beneficiaries, a nightmare. When in doubt, consult with an attorney and accountant to ensure successful completion of probate, payment of taxes, as well as debts, and of course, to reduce estate liabilities. Good luck. For more videos on estate planning and probate, please subscribe.